A short while. Good. Welcome members of the committee and also the technical teams from the Attorney General's chambers, the Ministry of Education, the Ministry of Justice, the Office of the Parliamentary Counsel, and the Law Reform. I think that's it, right? No other department. No, I mentioned the Ministry of Education. Child Protection and... All right. Well, as you know, this morning the main business, which I hope today will be the last meeting, to finalize the figures. The bills themselves had figures in terms of what should be appropriate for the sentence for murder, whether it's capital murder, non-capital murder, and then also for children. And we have had 9 meetings, right? 9 meetings, and we're hoping that, I was hoping that by the end of September we could have reported to Parliament, but we would really want to report within the next 2 weeks, make the presentation, the report to Parliament, and then we can just let other parliamentarians have their input into the bill themselves, into the report, and also they can have their contributions to their views and our recommendations to the Parliament itself, so that colleagues and the Joint Select Committee, the main thing this morning is to confirm the minutes, and then we go straight into the figures based on the bills that were placed in Parliament and the extent to which we might want to revise, support, as the case may be. So without further ado, I'm going to ask for consideration of the minutes. Do we need some more time to quickly glance through, or you're ready for... There are 3 sets of minutes: the 17th, the 18th, and the 25th. Okay, the minutes of the 17th. Any changes to? You have a copy? All right, the 17th. A motion for any corrections? None of those working? Come on. Come on. Huh? Yours is working. When you press nothing. That would be tragic. Charles, you want to come in the front? Sent to Charles. It should be sent to Charles Sinclair. The 7th line. Sent to Charles Sinclair. No, the 2nd paragraph. Huh? It should be sent to Sinclair. Okay. Come in the front, Charles. All right. If there are no other corrections, can we have a motion for the minutes of October the 17th, 2023 to be confirmed? Moved by Senator Gale, seconded by Senator Sinclair. Then the minutes of the 18th of October.
Third paragraph, Minister.
Page.
Page 3 of 14. The minutes of the 8th.
Page 3.
I don't think that 1, 2, 3.
No,
the
no.
Fourth.
On page.
Page 3 of the minutes.
Yes, go ahead.
Of the 18th, where it speaks to what Ms. Hamilton said. 1, 2, 3. Line 4. She mentioned that at the date of the meeting, 3 wards at the Metcalf Street Secure Juvenile Remand Center were uncontrollable, and other offenses wards were incarcerated for. I don't think that is properly. You could say that, and wards were incorporated for offenses which included.
Yes.
It doesn't communicate it properly.
You could say, and offenses. Wards are incarcerated for offenses which included. So the suggestion, should we say juvenile remand center were uncontrollable, and for other offenses, wards were incarcerated. What was it?
Posing is that we read the juvenile, 3 wards at Metcalf Street Secure Juvenile Remand Center were uncontrollable, and you want a full stop? And wards were incorporated for, wards were incarcerated for
Other
offenses which included.
Right, so shift other offenses, which included. Okay, thanks, Senator Scott Motley. Any other corrections? Most of these minutes were yours, Senator Scott Motley and Senator Gale. So, if there, and Senator Fraser Binns. So quickly make sure that you were quoted or referred to correctly. Okay, if there are no other corrections, can I have a motion for the minutes of October the 18th, 2023 to be confirmed? Senator Charles Sinclair. Seconded by Senator Scott Motley. Okay, so we then move to the minutes of last week, October the 25th. Today's what date? The first? Okay. All right. The minutes, last week's minutes. Yours not working now? Oh, no.
On page 3, the second paragraph, I believe what Senator Scott Motley said, and I'm sure she can speak for herself, but you know, she just got the copy. I believe what she said was that prisoners who were brought in on day 1, they were a different person within the 3rd week. So when you see them 3 weeks after they were brought in, they were very different from when they were initially apprehended. That's the second line, so on
Right.
paragraph 2, page 3.
In other words, the question is from the, well, right after 3 weeks.
And the person who you would see 3 weeks later were different persons, because the period of detention of 3 weeks had made them, instead of being vulnerable, instead of having the fear and vulnerability of the person when they were apprehended, it was replaced by a braggadocio attitude. I was trying to emphasize the difference that 3 weeks of incarceration could make on the human being.
I think,
so I don't know how
in other words, instead of when they leave, should be detained for 3 weeks, were not the same as when they came.
Yeah.
Yes.
Rather than when they leave.
Yes. I think that would address it.
Is that okay? We're not the same.
Yes.
We're not the same when they came. Right. Okay. A slight modification. All right. Any other corrections? All right, so the minutes of the October 25th, 2023, if there are no other corrections, can we have a motion for their adoption? So moved by Senator Fraser-Binns and seconded by Senator Scott Watley. Now, are there any matters arising from the minutes that members would like to raise? Why are those mics not working? I don't understand why they're not working. I mean, it would be, I'm sure it's must be some adjustment. Your mics are working over here. Just press and let me see if they. Yeah, they're all green light comes on. Yes. My dear, do me a favor, check the mics at the back. Let me see if they're working. Those at the back. Just press. Is it working? Okay, no. Once one green, come on. Let me see the next one. Yeah. All right, the one in front of you now. Marshall, there are about 6 brand new mics. I just want to make sure it's just a connection because. But over here, Marshall. I mean, I suspect it's not the mic. There's some connection that. Okay. You'll check on it for us, Marshall. I am sure it's just some connection at the back there. Colleagues, what we have before us is to finalize a report that will be sent to Parliament. As you will appreciate, these bills were before Parliament, and Parliament has referred it to this Joint Select Committee. And this Joint Select Committee, having heard presentations from a number of civil and public institutions and personnel, must now make a recommendation whether the bill with the proposals be adopted or whether they should be adjusted based on what presentations, if persons are convinced. At the end of the day, we have to accept that we can always make recommendations to the Parliament itself, and it's a matter whether Parliament will accept it or not. Clearly, you know, the presentation here and the reasons in support of any adjustments that we might want to make, we would support it and we would make that presentation to the House and the Senate when the bill is finally debated and a decision is made. I think colleagues will know that, speaking for the executive is very firm that punishment must reflect public sentiments and the public interest. And I think, to be fair, the public sentiment and the public interest is asking for harsher punishment for capital offenses. The feeling is that for the last 30 years or so, we have had far too many cases of murder being committed in a small country. And even though other measures are being used, the feeling also is that sentence should also reflect the gravity, the nature and gravity of the offense of murder. One of the concerns that we cannot ignore is that if sentences do not reflect the seriousness of the crimes, the possibility, not only the public express their dismay and disappointment, but at the same time, it also leaves open the possibility of retaliation and revenge within the community, within the society. Now, we do not deny that that sentence is ultimately in the jurisdiction of a judge, and we feel that the judge should take into consideration all the mitigating and aggravating factors. But at the end of the day, the legislature that reflects what the public, hopefully what the public thinks and feels, that it must also give some guidance to the judiciary of the type of sentences that we expect that the court will impose. And I can say, without fear of contradiction, that the Chief Justice, in several meetings of the National Council on Justice, have emphasized that judges basically stick within the purview of the law, so that if the society, if the legislature thinks that the sentence are inappropriate or the judges are not imposing sentences that reflect what the society wants, then it is a matter for the legislature to so define or put in the various legislations that come out. Truth of the matter is that we're starting a process of changes in legislations, and the truth also is that there are so many other legislations that need to be updated. We have legislations now where the fines are still $2 and $4, which, don't make sense. All of these legislations, we hope, will be updated in good time. But members will recall when the Firearms Act was done, a process began. And one of the reasons why this was urgent, in light of the sentences imposed in the Firearms Amendment, New Firearms Act, then the existing law or sentence on the statute book for murders would have been inconsistent with the New Firearms Act. One of the things which I think Senator Scott Motley was not too happy that the plea bargaining portion was affected in the Firearms Act. In other words, you so indicated in the discussion, but we're not going to trouble it in these legislations. So to the extent that for the capital offense for murder, if the person pleads guilty, then they could benefit, if I want to put it, benefit or be in a position to negotiate with the prosecution on a sentence. But again, bear in mind, the judge, unlike the United States, is the final arbiter of that sentence. So even though the defense might convince the accused to plead guilty on the basis that if it goes to trial, the likelihood is that you could be convicted. Obviously, if you're not guilty, you mustn't plead guilty. But if you think that defense counsel frequently encourage accused persons based on the evidence that if they think that they're not guilty, no, you don't plead guilty. But if they think that they're on the evidence, they will be found guilty, frequently advise the accused persons to plead guilty. Problems with that usually is that the accused persons usually want a minimal sentence in order to plead guilty. Now, we cannot ignore that unless the sentence is high, which is the case in the United States, the encouragement or persuasion to plead guilty and negotiate a much lighter sentence would not be there. In other words, if the sentence is, when you're found guilty, is going to be not as harsh, or should I say, is lenient, persons may well insist on going to trial. I can tell you there are so many cases, and defense attorneys who are here know that oftentimes people take their chance and suffer because having been found guilty, the judge said from day one, it's clear that, and then you go through all the, should I say, the nature and the seriousness of the offense, which immediately comes out in a trial. So, and most of it in the trial, they're aggravating factors. So to that extent, the sentence tend to be quite high. So colleagues, I just make these points, and I don't have a problem with some remarks from colleagues, and then we just have to go and just put down the numbers, whether we agree or we want to adjust them.
Well, let me say first an observation. I believe that based on the stories that I've heard, the narratives, people do react that way in the plea bargaining because they want a road sentence. Yet, under the Criminal Justice Administration Act, I don't know if it's because there's an element of understanding, knowledge, and certainty about the consequences if you plead guilty. Attorneys don't have such a challenge. And I think that, Minister, you need to bear that in mind.
Well,
I frankly don't understand the psychological difference which is created by certainty. But with the plea, I'm sure if you were to ask attorneys, they will tell you that invariably that whole negotiation breaks down because the accused man resiles from the sentence which is agreed at.
No, and that is always a possibility. And I accept it may happen. And quite frankly, has happened. I mean, there are many, and I think you know of many cases where the man agrees to plead guilty. And when he's told what the sentence is, he said, no, he's going to take his chance. So I understand. Anyway, the position is we're going to look first at the Offences Against the Person Amendment Act 2023, and in it, for capital murder, the present position is that the sentence is either death or life imprisonment. So for capital murder, its sentence is death or life imprisonment. If life imprisonment is imposed, the judge can go indicate it's life imprisonment without parole. But the judge, if the judge imposes a sentence, and the present law is that the judge cannot will impose life imprisonment and say you must serve at least, and the present law is 15 years. The proposal is to make it, the present law is 20 years. The proposal is to make it 50 years for capital murder. Bearing in mind, colleagues, that the capital murder is death or life imprisonment. But if a sentence of life imprisonment is imposed, then the present law, you must serve at least 20 years. And the proposal is to say, once you're convicted of of capital murder, and death is not imposed, life imprisonment, and I expect that in 9 out of 10 cases, it might well be life imprisonment without parole because of the seriousness of the offense. But if the judge, maybe because of the tender age, should I say that the accused might be 19 or 20, so the judge might well say, life imprisonment, you must serve 50 years. The last set of capital murders I saw was the one in Clarendon where the fellow was life imprisonment and you must serve 60 years, I think because of the number of murders. And in truth, in many capital cases, it's because there's more than 2 or more actual murders, okay? So let's make a decision. Do we agree with the 50?
So what you're saying is that when this person is found guilty, a judge has to say that you serve 50 years before you become eligible for parole.
Remember, the judge has the discretion, death.
Yes, either death or 50
or life
years.
imprisonment. In life imprisonment, it can be life imprisonment without parole. But the third option is life imprisonment, but you must serve X number of years before you can be considered for parole.
And that X number of years, what we're doing here is that X number of years would be 50 years.
Now, bear in mind, and don't ignore what we have said. If they plead guilty, they can go to plea bargain. And the 50 years might well be reduced to 30. I'm just giving an indication.
Right, but they cannot take...
That's a matter for the judge.
Yes, but there is no opportunity to plead guilty under the Criminal Justice Administration.
Yes. But
our starting point would be 50 years.
No, sorry. For capital murder, they can't plead guilty under the Criminal Justice Amendment Act, for capital murder.
Okay.
But for non-capital, they can.
And that takes into account, in arriving at our decision, we are taking into account the present state of our prisons, which you say we shouldn't take into account, but I can't disabuse my mind from it. And also, the cost to taxpayers. And not only that, but the fact that if somebody is sentenced, a 30-year-old person who is sentenced is an 80-year-old man, and the burdens on the state of taking care of the elderly population in prison is going to be devastating because we're not equipped for it. We're not equipped for taking care of old people, sick people. Minister, there are so many people of that age who have every known physical condition to man, diabetes, hypertension. It's just let me tell you, let me just finish, Minister. So I'm just saying that one has to take a holistic view of what one is trying to do. And whereas I know that the eye for an eye and the punitive aspect of it is compelling, I know that. I understand what the society is calling for. I mean, we see it even with Israel and the Palestinians, the eye for an eye attitude. And the consequences, I'm just saying that we should look at the consequences. For my own part, I believe that the increase in these sentences are far too dramatic.
Senator Scott Motley, may I just say that there's always the residual possibility, put it no stronger than that persons in custody who are ill, disabled, they can appeal to the Governor General. And there are many old persons who have been referred to old people's home outside, leave the prison, go into halfway houses, into various other facilities, especially if they're sick and can't be cared for. So that's always a possibility. And I do appreciate the empathy you towards old persons who may be there and die in prison. But, Senator Motley, you cannot ignore the demand of the society now for these grievous offenses which occur, where at the moment you see the senseless, heartless contract killers. These contract killers have no empathy towards their victims, and the sentence of the court must reflect that.
And respectfully, Minister, I don't think that there is anything in our present sentencing arrangements which prevents a judge from taking that into account. You just mentioned the cocoa piece killer. I am from up that way. To reach with the hall, you have to go through cocoa piece. I understand how the community feels because I was a part of that community. It got 62 years. So there is within, if you look at even the murder sentencing table which the DPP sent us to guide us, Minister, those are not light sentences which were given. But let me say this, the government is determined to increase the mandatory minimum. That's a fact. The question now which confronts us is, should we agree to a 300% increase? Should we agree to a 200% increase? My view of it is that since we cannot shift government policy, because this is what is on the table for us, we should try to arrive at a just increase. People, it just occurred to me. I'm not going to say what occurred to me. Okay, I was saying people don't increase things by 300%.
No,
but
no,
I'm going to
no,
withdraw. I'm going to withdraw that immediately.
We're moving from 20 to 50. Look at this. What is your proposal? We're moving from 20 to 50. We're talking about capital murder, where the sentence is either death or life imprisonment. The possibility it could be life imprisonment without parole, but if the judge is going to say life imprisonment or X, what should X be? So the proposal of the executive is 50 years. What is the proposal of just this joint select committee appointed by Parliament, so it can go back to Parliament for Parliament to either accept or adjust as the case may be? No problem. Yes. and by the way, you know, I must let you know that when these were presented in Parliament, there are people who called to say we should increase them. Just to show you. In fact, there are persons who believe that for capital murder, it should be life imprisonment without parole, no question of parole. Which, to be frank with you, as I said, in many cases, that is actually what the judges impose. So this one, to be frank with you, this one, my view is that it should be high. And the reason why it should be high, this one in particular, because we're dealing with capital murder. We can do a little with non-capital murder, but for capital murder, I think it should be high because the usual thing with capital murder is life imprisonment without parole. Now, why we should have that adjustment, that it could be a sentence with a number for parole, just in the event that the person pleads guilty, then the judge would be guided by what the minimum mandatory is in the legislation to reduce it. The judge might reduce it by 33% or 50% if the person pleads guilty, depending on the nature and gravity of the offense. Yes, Senator Sinclair.
Thank you, Mr. Chairman. Since we are here, and it may give persons speaking here that we are basically speaking amongst ourselves, but there's a listening public. And if we could just have it stated specifically so that they appreciate it, what it is that encompasses capital murder. If that could just be listed.
Well,
the specified matters that take a murder into the category of capital murder.
capital
that
murder.
When persons
you have-
express their view amongst the members here.
No, let's just get it done, Paul.
Yeah.
Could you just read for me exactly what amounts to capital murder? Just read it from the act itself, rather than me
Yes.
giving a synopsis.
Okay, Minister. So the circumstances of capital murder are stated as Section 2(1)(a) to F of the Offences Against the Person Act. So it includes the murder of a security force, a member of the security forces acting in the execution of his duties, or a person assisting a member so acting, a correctional officer acting in the execution of his duties, or a person assisting a correctional officer so acting, a judicial officer acting in the execution of his duties, or any person acting in the execution of his duty being a person who, for the purposes of carrying out those duties, is vested under the provisions of any law in force for the time being with the same powers, authorities, and privileges as are given by law to members of the Jamaica Constabulary Force, or the murder of any such member of the security forces, correctional officer, judicial officer, or person for any reason directly attributable to the nature of his occupation. The murder of any person for any reason directly attributable to, 1, the status of that person as a witness or party in a pending or concluding civil case or matter in any criminal proceedings, or the service or past service of that person as a juror in any criminal trial. The murder of a justice of the peace acting in the execution of his judicial functions. Any murder committed pursuant to an arrangement whereby money or anything of value, 1, passes or is intended to pass from one person to another.
That's the contract killers.
Yes. Or to a third party at the request or direction of that person, or 2, is promised by one person to another, or to a third person at the request or direction of that other person, as consideration for that other person causing or assisting in causing the death of any person, or counseling or procuring any person to do any act causing or assisting in the causing of that death. F, any murder committed by a person in the course or furtherance of an act involving the use of violence by that person which, by reason of its nature and extent, is calculated to create a state of fear in the public or any section of the public. Yes, so 1A as well, it says, for the purposes of subsection 1A, the offenses referred to in this subsection are burglary or housebreaking, arson in relation to a dwelling house, robbery, or any sexual offenses.
Thank you, Paul. So, just for the listening public, SG, you wanted a correction?
So there are another circumstance in which capital murder is committed. So this is the 2(1)(a) that would have started the provision. It says any murder committed by a person if, in the course or furtherance of, arising out of, or auxiliary to that murder, the person commits an offense referred to in the 1A, and that's what I would have just listed, the arson, or any sexual offense, or committed by a person in the course or furtherance of, arising out of, or auxiliary to an offense referred to in 1A.
Right. Thank you, Paul.
Just a quick question. Isn't there a situation that you have capital murder if there is a second you have multiple murders?
Yeah, there is a provision there for multiple.
Pardon me?
Sorry, SG?
Thanks. That would be 2(2), subject to subsection 3, every person convicted. Hold on.
Could you read it for us, SG?
No. I thought it was. No, give me a second, please.
We made a compromise. So you have an opportunity to get a reduction.
The position, though, Senator Sinclair, is when in the 90s, I think it was about 93, that the then government separated the death penalty or murder into capital and non-capital and reserve the death penalty only for capital. The idea was to carve out the most serious types of murders for which a death penalty could have been imposed.
And that is why I'd asked for the listing.
Sure.
So that everyone appreciates what it
The
is
gravity
that
of
we are
the
dealing
offense.
with.
Yes.
And so when I say that I am supportive of the 50 years minimum in these circumstances, then persons who are listening out there is not believing that I'm just being frivolous or just because I'm a member of the government side. That is so.
Well, bear in mind, the two other alternatives is death or life without parole. So it must be something close.
And as you have indicated, Mr. Chairman, that if a person wishes to go below, then you can negotiate once the evidence
you
is
come
so
with your
weighty.
plea.
Very well.
Okay.
Thanks, sir. I found it. So it's in 31A where it says capital murder, basically what we call capital murder, are those that fall within 21A to F, which Mr. Bailey read, or to whom subsection 1 big A applies. And 1 big A applies if the person who is convicted of murder and who before that conviction has been convicted in murder in Jamaica, A, whether before or after the 14th of October 1992 of another murder done on a different occasion, or B, of another murder done on the same occasion. So that would take into account this. Yes, it takes it into capital murder.
No, Joyce, yes, Ms. Cottrell is going to be in touch with you today. We know about it. All right, thanks. Sorry, Senator Williams. Sorry, not Senator, MP Williams. Sorry about that.
Yes, I am in agreement with my brother, Senator Charles Sinclair. And I support the 50 mandatory minimum on the basis, one, the egregious nature of capital murder, and two, the fact that there is recourse to the convicted person, to the accused, depending on the sequence, to the Plea Negotiations Act. I think by allowing the recourse to the Plea Negotiations Act, by allowing that act to be operational in these circumstances, to me, is a compromise that an accused person could take, could make use of. And so I'm in support of the 50 on that basis.
Well, we're going to the second row, but no, but the position is on capital murder. I believe when we get to non-capital, because of the range of non-capital murder, the sort of rainbow of the gravity, the nature and gravity. But for capital murder in 1992, the idea was to just carve out the most serious offenses to make them capital. And that is why, we have to reflect, reflect the seriousness in the gravity of the sentence. Senator Gill.
Chairman, in the first instance, when I look at A, B, C, and D of section 3, and we're talking about C, capital murder, and that's based on the explanation given in defining capital murder, it appears to be the most egregious nature of an act. And so this committee, in seeking to treat with the public sentiments, has to display what would be the creation of the highest level of a deterrent. And so we also want to be able to restore public confidence in the judiciary system. And so it is in my view that this is the one that ought not to exhibit any level of flexibility. And so I'm supportive of creating that the highest level of deterrent of the 50 years.
Okay, thank you very much, Senator Gale. Senator Scott Motley.
Minister, I first of all don't want the public to misunderstand my expressions. I support sending a strong message through sentencing of how abhorrent one feels towards murders. Indeed, when I heard contract murders, that is to me the most repulsive of all, that you could actually accept payment to take the life of another person. However, as a legislator, I think it is my duty to show some balance. When this sentencing regime was created in 1992, the legislators then wanted to communicate to the public exactly how they felt about the capital murder as opposed to non-capital murder. And they approached it with, I think, I don't want to, the sentence of 20 years. Am I?
No. Life imprisonment.
Life imprisonment.
But must serve 20
but
years
must serve
before
20 years
eligibility
before
for
being
parole.
eligible for parole. I find a jump to be extraordinary, and I would propose that even a doubling, but I find just the thought of serving 50 years in prison is to me so repulsive. You know, I listened very, very carefully to some of the submissions that were made. And I think it was Ms. Hamilton who said that there are people who even do their degrees in prison. And I asked myself, so if I did a degree in prison, how would that serve me well if I had to be there for this long period of time? I would have demonstrated my remorse, my desire to become rehabilitated into the society, an aptitude which I had never displayed before. But it does not serve me in any way because I have to serve this kind of sentence. And I think about what incarceration does to a person, because I cannot escape that. I think 50 years is just too long. I do think 50, I don't know how the government came to that. I have been trying to search around for some data. I have been trying to look at the justification for this amount, and I cannot.
I help you a bit by saying how that was arrived at. The two alternatives were death or life without parole. But the reason you need to give some guidance to the stakeholders, if there was a plea of guilty, then you would not necessarily want to put life without parole. So to the extent that you say that there's a guidance that 50 years is the figure if you were found guilty after a trial, but you have pleaded guilty, then that guidance is there for the prosecution, the defense attorney, and the judge to say, well, take off 10, take off 20 years, you know, because you have pleaded guilty.
But the truth of it is that we have sentences where now it's life without parole.
Yes.
And we do have the sentence of death, which has not been used because the last time we hanged anybody was in 1988. So it's not new things that we are considering. In other words, the same situation existed in 1992, and the same situation exists now.
No, but
it's not new. The only thing that we are introducing, which is new, is the length of the sentence.
But Senator Scott Motley, I can tell you that the sentiment of the vast majority of people out there is that a person has committed murder, especially capital murder, that they should not see outside the wall of a prison. And to be frank with you, they even insist that we must return the death penalty, as you know.
There are in prison right now, Minister, persons who enjoy a certain amount of freedom. Say Vibes Cartel, he's still making his music. But for a lot of people, they are just simply bodies locked away. I don't know, Minister. I know that the government is determined. I am only articulating my own position. So my proposal would be, reluctantly my proposal would be that there shouldn't be more than a doubling to send a message.
So your proposal is 40 years?
My compromise, you see, let me tell you what faces me as I reflected on it. The government wants to do this. There is nothing which is going to dissuade them. Do I simply go ahead with what they're proposing, or do I compromise with a lower figure? Because I just believe that if the taxpayers ever know how much money they're going to spend to send away these people for 50 years, you would see a total shift in their opinion. But what I'm saying is that I'm willing to compromise, not to propose, but to compromise.
Senator Binns, yours not working yet? Oh, no.
Mr. Chair, are you hearing me now, sir?
Huh?
Are you hearing me?
Yes, yes.
All right. Mr. Chairman, when we commenced this committee, and I remember a comment was made by the DPP, and I said at the time that one of the things I believe people want to know, and which would deter crime, is the certainty of being caught. At the end of our committee, I still maintain that position, that I believe what the country wants to see and what would be a deterrent to crime, perhaps even more than sentences, is a certainty of being caught. If somebody knows that if they take up a cup of coffee that's not there, they're going to be caught and prosecuted, I believe that in and of itself would be a deterrent. That being said, I have listened to all the presentations, including your own plea, and I understand that the government is a government, and the government has to rule, and as opposition, we don't have the luxury of helping the government to rule. And in that regard, I have to accept the quest of the government for this 50 years. But I believe, sir, that it is not the answer. I have looked, well, last week I sought to ascertain from you the reason for the 50 years. And I was not convinced of a reason. You sought to give a reason this morning, which I understand. But again, I am not convinced that there's a scientific basis for choosing 50 years. I, however, had the opportunity to read through in detail this document presented by the DPP's office, Sentencing Table for Murder 1993 to 2003. And when I looked through it, and bear with me a little, but when I looked through it, I saw a range of sentencing, including death. So, for example, if you look at page 2, sorry, let's go back to page 1.
This is the matrix.
This is the matrix from the DPP's office. So when we look at page 1, the Roderick Fisher matter, he was sentenced to death in 2000. In 2006, he was resentenced, life with parole for 40 years. We go to page 2. We see...
What page are you?
Page 2, sir, Peter Dougal.
No, it's not the matrix, sir.
It's the DPP's presentation.
Oh, DPP presentation.
Yes. 1993 to 2023. On page 2, we see Peter Dougal. He was initially sentenced to death, and then it was on appeal, life with parole. Then we look at Ian Gordon, 2023, sentenced to death, on appeal, life with parole, 30 years. Jeffrey Perry, life with parole after 45 years. We see Michael Allison O'Neill Hamilton, murder of 3 persons, sentenced to death, life with parole, on appeal, life with parole, 40 years, after 40 years. And it continues on page 3. Calvin Powell, home invasion, 2 persons killed, sentenced to death, life with parole, eligible for 30 after 35 years. And it continues on page 4, page 5, and page 6. But why do I raise this, sir? I raise it because if one looks at these sentencing provided by the DPP, it covers in part the offenses that were highlighted by Mr. Bailey, which we call capital murder. And it is my considered opinion that the very fact that the judiciary was able to pronounce these sentencing and the number of years on these persons who were found guilty confirms in my mind that the judiciary has the ability and ought to have the freedom to continue what it is doing and not be limited by a minimum sentencing. That is my opinion. We have seen it at work in the very work presented to us by the DPP. But even if one were to consider a minimum sentence, I again looked at the table provided by the DPP's office and sought to do a count, which is not 100% accurate, because I didn't finish all of them. But within that count, what I saw, and I only looked at this time at what is deemed capital murder, we had 5 persons sentenced for 30 years. We had 5 sentenced for 40 years, 4 sentenced for 35 years, and 2 for 45 years. And we can always go back through it and check. But the point I'm making is that when one looks at what obtained between 93 and 2003, that's 20 years? And 2023, then it is clear that we already have information that can guide us in making a scientific determination if the government insists on having a mandatory minimum. And consequent upon the presentation from the DPP's office, I believe that a middle ground for mandatory minimum would be 40 years. And that is based upon my reading of the information provided by the DPP's office. In addition to which, I want to say one more thing, Mr. Chairman, and that is, while we focus, as is our TOR for this committee, on the mandatory minimum sentence, that we recommend to the government that in having the mandatory minimum sentencing, there are certain things that the government has to do. There are certain areas that the government has to invest in. Some of which will fall in your portfolio as Justice Minister, others in your colleague ministers. So we have to ensure that the technology is present. We have to ensure that the investigative arm is trained and is provided with all the resources that they need. And I mentioned earlier
and we want to thank, remember, we're going to take that into consideration.
I know, but so I'm just telling you
part of the report. Right.
I'm just telling you my view, sir, and my recommendation. So, Mr. Chairman, whereas last week you mentioned that we should try and not conflate all the issues, I believe that we cannot afford to discuss mandatory minimum sentence in and of itself without looking at all the other factors, some of which were raised last week, some of which have been raised over the period of this deliberation, and one of which was raised this morning by Senator Scott Motley, including when one is sentenced to 50 years, the implications for our prison system having an older population. And that is underscored by the figure presented by, I think it's the court management system, the court management service, when they look at the age group of persons committing offenses between 2016 and 2022, the age group, the majority of the age groups stem between 18 and 50. That's 70, and that's probably 85% of the persons who commit murder between the age of 18 years old and 50 years old. And consequent upon that, we can't divorce ourselves from the consideration of the other effects it will have on the court system. So in wrapping up, sir, as I said, I do not support the 50 years, but I believe Senator Donovan, that MP, I believe that a reasonable minimum would be 40 years, based on the information.
So you are in support of Senator Scott Motley of 40 years. Senator Golden, is it working? Senator, is it your right?
Minister, I didn't put up my hand, you know.
Huh?
I didn't put up my hand.
No, but I'm asking you for your proposal.
Oh, you want my proposal?
Yes. We need the views of everyone.
I thought I had completely expressed them throughout the committee. Minister, the capital murder is the most egregious thing that you can be accused of committing. So for me, people who are found guilty of that should be gone out, should be removed, quite frankly, from society. They should be locked away. I'm not a believer in the death penalty, personally. But the truth of the matter is that I really don't have any evidence that has been brought to the committee as to whether or not it should be 50 years, 40 years, 30 years, or 70 years. I don't have any. Nobody has made that submission as to why I would choose 50 over 40 over 70. So I'm going to go along with the proposal that is before the committee. I note, though, that I had raised the issue about if a convicted person were to challenge their sentencing under 42K, they have room to do that, and they can appeal, and the Court of Appeal can rule. But I just wonder if the committee has noted that of this document that the DPP has provided to us, with all these trial court sentences, that only on a few occasions were they affirmed by the Court of Appeal. The majority of the time, according to this document, the Court of Appeal lowered the sentences, right? So while we may place this in the law, I have no difficulty. Like I said, if you are somebody who is involved in a situation where you are plotting and you are committing capital murder, I personally don't believe that that person is particularly given to being rehabilitated, but I'm not God, I don't know, right? But that is the worst thing you can do in any society. So there ought to be a very extreme punishment for that. But we must follow our data. We must read. We must analyze. And what has been provided to us shows that even if we do this, we may well be in a situation where we have more cases on appeal, and the appeal court reduces the sentences. That's not an argument for not doing this, you know. It's just an argument to say we still may not get the result we want.
No, you know, there's no doubt that sentence, even the judges will admit, is not a scientific thing. You know, so to the extent that we have heard from the presenters, where's the rehabilitation, where's the deterrent, and also the question of prison population. But the legislature has to do what it has to do. You see, so what's your position? You said you will go along with what is in the bill.
I'm saying I'm going along with it, but I also want it recorded that I'm not really so happy about the methodology by which we come to these decisions.
Okay.
Okay. That said, we're talking. This is you're garnering for the question of just capital murder.
Just capital murder.
Right,
for the moment.
and we're talking about capital murder in relation to adults.
Adults, yes.
Okay.
All right, so basically, let me just say that I am supportive of in this case, 50 years for capital murder. So the report will indicate that the committee, by a majority, agreed to 50 years, even though the minority had proposed 40 years. Okay? We'll just put that as in relation to capital murder. Now, in relation to non-capital murder, the present sentence is life imprisonment or a fixed term of imprisonment. So when we say non-capital, no, it is those that are not capital. You will find that in relation to non-capital murder, there is this range of circumstances in which non-capital murder is committed. To be frank with you, many of them are actually murders between friends, domestic murders, that's the non-capital. But in the offense itself, the prosecution would lay the charge for murder because the prosecution feels that it can prove deliberate intent. If in fact the defense or the accused had mitigating circumstances like diminished responsibility or provocation, then there's no doubt that these are matters that can in fact reduce the offense to manslaughter, and possibly, you know, a conviction or a plea of manslaughter could reduce whatever the sentence is. What we can't ignore, however, is that in this type of case, you're going to have persons who feel that they were acting in self-defense. So they will go to trial because they feel that self-defense will succeed. But sometimes the prosecution is able to negative self-defense so that the person is convicted for murder. But in many of these self-defense cases, it usually has the alternative, the possibility, put it no stronger than that for the moment, that the person was provoked before they started to so allegedly defend themselves. So, but I can tell you that when you look at the non-capital murder, the range is quite high. The range is great. And therefore, we have proposed that if the person was sentenced to life imprisonment, that it should move from 15 to 45. If they were given a fixed term of imprisonment, where the fixed term should not be less than 40. Is that right? Am I right, Mr. Bailey? If in non-capital, if a fixed term was being imposed for non-capital, it's 40. Sorry, no. The fixed term must not be less than. What is it? It's
Mr. Chairman, repeat what you're asking. I wasn't following.
no. We have made a decision on the capital, but for non-capital now, there are two possible sentences. That is not there. So it's either life imprisonment or a fixed term. At the moment, if life imprisonment is imposed, then the minimum that must be served is 15 years before being eligible for parole. But if a fixed term is imposed, then at the moment it is 30 years? Sorry? At the moment.
Sir, at the moment, in the current law, it's 10 years that must be served if a fixed term is given. 10 years must be served if a fixed term is given.
But we didn't put a minimum for the fixed term. In other words, the judge can sentence any, but must serve 10 years.
So there is a fixed term in the law now, and the fixed term is mandatory minimum 15 years. And then if life imprisonment is given, they must serve 15 before they're eligible for parole. If a fixed term, which cannot be less than 15 years, is given, they must serve at least 10 years.
So what is being proposed in this bill is that if life imprisonment is imposed, then they must serve. Sorry.
Based on the proposal that is in the bill, can we take them one by one?
That's the point.
So that we can get the explanation that supports the proposal, and then we can make a determination from that.
Well, I was giving you the alternatives. So what is happening is that for non-capital, there are two possibilities: life imprisonment or a fixed term. In the present bill at the moment, if you're sentenced to life imprisonment, you must serve a minimum of 15 years before you're eligible for parole.
So that is subsection 1B.
Right. Now, the proposal in the new bill is that it should be increased to 45 years.
45.
Fine. Now, if a fixed term is imposed, it is being proposed that that fixed term should not be less than 45 years. Is that correct? And you must serve at least 35 before being eligible for parole. Colleagues, I mean, this is where I would be very happy to hear proposals in terms of where I'm very firm about the capital murder. I think because of the range of possible offenses, you understand, in the non-capital murder, one could be not as harsh, if you put it that way, as in the capital murder. But so we are going to go through again and get the views of each person. So we're going to start with you again, Charles. So remember, we can start out with if life imprisonment is imposed, what should be the minimum sentence to be served, because for non-capital, but it may well be egregious so that the prosecution might say this, even though it is non-capital, they would want to argue for life imprisonment. If you get me? Even though it is non-capital, that's one possibility. And if that is what the court is going to impose, what should be the minimum that should be served before being eligible for parole?
The question that I want to get an answer to before I state my position. Can anyone assist me with saying why it is that why that two-tier situation was created?
You mean in non-capital?
That is correct. Where you have the situation, as you just explained, where you have the life imprisonment, and then you have where the minimum would be 15 years, and where you have the fixed term. And then minimum.
I think it's very important to note. If it is life imprisonment, even if you serve, say, 20 or 30 years, and you're released, you're still serving your sentence
Yes, I understand
outside.
that. Yeah, yeah.
But if it is a fixed term, and let us say the fixed term given was 30 years, and you must serve 20. After you serve 20, you only serve another 10 years before you're totally free, if you get me. So if you are given, put it differently. If you are given a fixed term of, no, that's my understanding. If you're given a fixed term, the way the correctional services put it, after your sentence is completed after two-thirds. Right. So basically, if you were in the prison after two-thirds of the sentence, you go out as a free person. If it is a life sentence, even though you go out, you're still eligible, put it no stronger than that, to be returned to the prison if you breach the conditions of your release.
I appreciate that, Minister, but I'm just still trying to understand why, if someone can provide me with, what was the thinking that created that two-tier situation when we're speaking about murder?
No,
non-capital murder. Let me.
Go ahead.
No, I was trying to understand what, when persons are talking about a fixed term, you mean the mandatory minimum?
No, what I am understanding exists is that a person who is convicted of non-capital murder, that person can be given life imprisonment.
You're given a fixed term. Let us say you're given a fixed term of 45 years. And we say you must serve at least 20 years, for example.
Yeah.
The way I understand that the law works, after 30 years, if you were released after 20 years, then you would be released to serve another 10 years. Because normally, if you behave, you only serve two-thirds of your sentence. Sorry?
I'm a little confused because I'm going to read from the Act. Yes. So 3(1)(b), every person who is convicted of murder falling within, and this is now what used to be non-capital. And I look back at the old law, and the reason we say capital and non-capital is because we used to call them capital and non-capital. And then after a line of cases, starting with Pratt and Morgan, we had to make some major amendments. And it's because of that we have now this complicated scheme. I'll say it's complicated because before, when we're looking back at the old law, it was quite simple compared to this. So I'll go again. 3(1)(b). Every person who is convicted of murder falling within Section 2(2) shall be sentenced to imprisonment for life or such other term as the court considers appropriate, not being less than, right now it says 15 years. Mm-hmm. That's not a fixed term, that's a mandatory minimum. Yeah. Well, the fixed term could be the life imprisonment, but the fact that you give the alternate, which is imprisonment for life or such other term. And that had to be done because of the case law. Because you'll recall, at first you had persons just being sentenced to death for capital murder, and there was no alternative. And the Privy Council ruled that was unconstitutional. So this is why we have alternatives. So it's death or life, and then you have life or such other term. Now when it goes on to do the not less than 15 years, and then below in 1(c)(b), you will have a court can impose a sentence of imprisonment for life. The court shall specify a period being not less than 15 years, or any other sentence of imprisonment. The court shall specify a period being not less than 15 years, which that person shall serve before becoming eligible for parole. That was put in because of the dictates of the Parole Act.
Okay.
So,
right. So let me just go further. So what is the position now? The position before this bill? For non-capital murder, the court can sentence a person convicted of non-capital to life imprisonment or to a fixed term, which must not be less than 15 years. Such other sentence. But any other sentence other than life imprisonment, it must not be less than 15 years. Okay? The proposal of this bill is to say it must not be less than 45 years instead of the 15 years. In addition to that, if the person is sentenced to life imprisonment, the present position is that you must serve at least 15 years before being eligible for parole. The bill proposes that that 15 years should be increased to 40 years. And if a fixed term, not being less than 45 years, is imposed, then the person must serve at least 15 years minimum mandatory before being eligible for parole. Go ahead, Mr. Bailey.
So, Minister, I just wanted to just kind of confirm what SG was saying before about the utilization of the terminology fixed term, that it's a technical term not reflecting what exactly is in the provision. What is in the provision
It's alternative rather than fixed term.
Minimum
Alternative to the life imprisonment. So, colleagues, what is before us now for non-capital murder? If life imprisonment is imposed, what do you think the minimum mandatory sentence should be before being eligible for parole? If the court intends to impose a fixed term, an alternative to life imprisonment, what should be the minimum sentence that the court should impose for non-capital if the court is going to impose a term other than life imprisonment? In addition to both of those possibilities, what should be the minimum term to be served, minimum mandatory term to be served before being eligible for parole? The bill says that if it's life imprisonment that is imposed, then they must serve 40 years. If it is a fixed term to be imposed, they must serve 30 years. Is that before? No, there's no term. Yes. 35. No, colleague, this is where you need to just put your mind and bear in mind, as I said earlier, the range of offenses for murder is quite wide.
I'm still having a little challenge.
Yeah, yes, Senator Sinclair.
Let me tell you where my challenge is. Why do we have to maintain this, as you refer to it, as more complex type of situation? As against a situation where if a person is convicted of murder, which we are classifying as a non-capital, it doesn't fall in the category as we had listed them out earlier. That we have to, and if you can, I need your guidance on that. Kevin. What cases would be a situation where a judge would have, in the case law, as you have said, imposed the fixed term versus a life imprisonment and then come to the minimum of 15 or, as the case may be, 10? Tell me, distinguish the cases for me.
Oh, so, yes, no, but I wouldn't be able to, I think you would need DPP to guide you through. Yes, because...
You don't have that, Mr. Bailey?
No, because that would happen, so in sentencing, the court is supposed to take into account a number of things. If it's just straight sentencing without plea bargaining.
I appreciate it.
Right. As to why a court would go above the mandate, because I think, certainly from some of the data from the DPP's office, the courts don't really the judges don't sentence at the mandatory minimum. They go higher than the mandatory minimum. And when you look at the sentencing guidelines, it gives the judges the scope as to how they determine what they think is appropriate, but they are also supposed to look at similar cases because, you know, you're supposed to have some sort of consistency. Again, also coming from the sentencing guidelines. But I did notice that a lot of the sentences aren't at the mandatory minimum. They're actually higher than the mandatory minimum.
Yeah,
but I think you would need DPP to perhaps...
I understand that, you know.
I know. But I think it would be DPP who would have to explain.
My problem is in simplifying the thing to say, guess what? You're convicted of what we are speaking about. You're not in the capital murder group. Then you're sentenced, convicted for murder, life imprisonment, parole after a period of time. Pardon me?
Wanted to just
Once you are convicted of murder.
Including non-capital.
Pardon me?
And I mean non-capital murder.
Yes.
It should be life imprisonment.
It is life imprisonment with parole after whatever period of time that we settle on.
There's a reason we have the alternative, and it was because of the mandatory nature of a penalty and the fact that, well, the courts have ruled that the mandatory death penalty was unconstitutional.
Right.
And so the thought process was that a mandatory sentence could be seen as unconstitutional, which is the reason you have the alternate, which is life or
I got you.
another term.
Quite.
And then you put in the mandatory minimum to avoid the early release because of parole.
Okay.
So Senator Charles Sinclair.
All right.
Senator Sinclair, let me just add to that. That's a good point SG is making. Your position would be it's non-capital, should still be life. That is why when we look at the present position, the alternative being 15, it didn't make sense. It should be closer to life. And that is why it went up to 45. You see, so you have those two suggestions to make, whether we agree with the 45, which is close to the alternative of life, or you reduce it or you add. People believe that, quite frankly, this is one in which persons believe from you commit murder, it should be a long period of sentence. But in all sincerity, let me say this as one who has looked at, a wide variety of murders. Even though a person may be convicted of non-capital murder, in more than half the cases, there are strong mitigating factors. Even though the person is convicted of non-capital, bear in mind, I have no problem with capital. For capital murder, there are very little mitigating factors. In fact, most of them are aggravating factors. But when you get to non-capital, you find that a lot of it is between parties who know one another. And some rage, some blowout, and before you know it, murder is committed. So oftentimes, you find in court that the defense attorneys are always pleading very hard with the mitigating factors. So these are ones which you should bear in mind in making your suggestion.
But because of the fact that they are mitigating factors, there is the proposal of providing alternatives.
Quite.
Right. And so the challenge I'm having, Chair, is that what is before me is what is being proposed as to the changes. But I would like to be able to examine in detail what the present act says. The alternate, it's easy for you to represent it and for me to get it verbally. But for me to make a distinction that allows for a clear and precise decision, my preference would be to be able to look at it and to be able to say to myself, these are the alternatives, and maybe ask questions as to why. And so in making a decision on this aspect of non-capital murder, where there are alternatives, I'm suggesting that we be presented to what the actual legislation says no.
Yes,
in order to allow.
No, and what the legislation says now is that it is life imprisonment or a term of imprisonment which must not be less than 15 years. We are now modifying that to say life imprisonment or a term not less than 45 years. So the question is, do you agree with that? Yes, that's the first thing. So we can discuss that first, and then we go afterwards to what is the minimum mandatory to be served. What's your position then? So we're talking about that particular section where the suggestion is to move from 15 to 45, fixed term. The alternative term. The judge must not sentence to less than 45 years. At the moment, it says less than 15 years. What is the suggestion? Because as Senator Sinclair says, the alternative to life imprisonment, it being 15, really was way out. So that is why I said 45 is, a figure that more reflect being convicted for murder. Yeah, Senator Sinclair, you want to start? We're dealing now with just that particular section, not with the minimum mandatory for the moment.
Chairman, with the explanations that have been made and the various comments, in relation to the first, which you have at 45, I had 40. And in relation to where you have the option of the fixed term, that the minimum is 30.
So you're saying, no, one second.
Where you have the 45.
You'll go to 40.
I am at 40. And where you have the 35.
No, the 35 was the minimum to be served before being eligible for parole. Paul?
No. No.
So, no.
Yeah. Yes, we have the life imprisonment with the parole is 40.
Right.
Yeah.
And
You had 45.
All right, and so you would want to go to 40.
Yeah, I'm comfortable with 40.
And that's one category. Now, if the alternative sentence, the proposal is to move from 15 to 45. What's your position?
It was 35.
You'll go to 30?
No, you had 35.
No.
Isn't that what you had?
Huh? 15 to 45.
You have in the bill in 2D.
1B.
No, 2D.
What is 2D referring to? Because that's the only one that speaks to 45, 35. And that is substitute, that is seeking.
This is, right, this is the one where in the present law, if the alternative sentence is not less than 15, the minimum mandatory to be served was 10. We are now saying that the 15 should move to 45 and the minimum mandatory to be served is 35. I mean, those are proposals. Is that correct, Paul? Huh?
So yes, Minister. So I'm thinking for the sake of clarity. All right. If it is that we're treating with the sentence that the judge must give, that is under section, that is 3(1)(b). Right. And the judge has the option of life imprisonment or a fixed, let me not say fixed term, or a mandatory minimum, or a term of imprisonment not being less than 15 years. Our proposal is we're going to replace 15 years with 45 years. Right. So that is one question.
Let's deal with that first.
Right.
And get that out of the way.
And that is the one I had put for 40.
Right.
You had 45.
So let's deal with that.
No, just pull the mic closer to you.
Sorry. I want us to deal with that one first, and let's get that one out of the way.
That's 1B.
That's
3(1)(b).
That's 3(1), no. Yeah. That's 3(1)(a). Sorry, 1B.
3(1)(b), yes. So, Senator Sinclair, would like to move it where it says life or a sentence not less than 15. The proposal is 45. Senator Sinclair would say 40. What's your position then?
I would support the 40 because I believe it ought not to be as close to the
50.
capital.
Right. Okay. Donovan, MP Williams.
Go a little lower than my colleagues in relation to the first tier. I'm thinking a minimum of 30.
You would go to as low as 30. By the way, that is not to say the judge can sentence so higher. But whereas, remember the law now says, the judge can sentence to less than 15, which as you can see with the Firearms Offences Act, it just seemed to be inconsistent that for murder the judge could sentence to 15 years. So when we move it to 45, that was what being proposed. What MP Williams is proposing is that instead of 15, he would double it to 30. Is that my understanding,
Yes,
MP
Williams? Yes, Mr. Chair.
Senator Scott Motley and Senator Binns.
I don't have any analysis of the sentences which have been given. I don't have a real sense of what it is that we are trying to address. I know that every time we discuss it, it goes back to what somebody has died. And in 1992, somebody had died too. So if I'm going to move from a sentence of 15 to 45, which is what, my maths is not so good. You are mathematics special.
It's triple.
So it's triple. If I'm going to move from 15 to 45, I must have something before me that guides me to that figure. And I don't have it. I don't have it, Minister, and I'm respectfully saying that to say to me that somebody has died is not sufficient because we are talking murder. And we've been talking murder throughout all the ages. And we have been sentencing people for murder throughout all the ages. When I look at the sentences as to what the DPP has provided, they're quite high. They're above the 15 years that we are discussing, most of them. So that judicial discretion has intervened and has determined that they will simply use the military mandatory as a guideline for sentence. And then they have the ability to examine each case having regard to its own issues, to its own facts, to the issues raised therein. And respectfully, sir, there is nothing that the government has put before me that justifies a 300% increase in sentencing. Just not. So respectfully, I would prefer not to suggest.
Sorry?
I would prefer not to suggest an amount. I will leave it
What
to...
would be your suggestion?
I don't have one, sir.
Okay. So you have...
I'm not insensitive to the fact of the message that the government wants to send. I'm not insensitive to that. But to me, everything that one does as a legislator has to show an element of balance. And I don't think that moving from 15 to 45 is balanced. But I would prefer, Senator Sinclair, not to react emotionally to something of this importance. I would prefer to have been guided by something beyond how the public feels. Because, Minister, it's just that I believe that the legislator has a role beyond responding to the public. I do believe that the legislator has a role in guiding public sentiment and explaining to the public what considerations are taken into account when they do this very important task. Indeed, I think the legislator and the public should also put themselves in the position of somebody about to be sentenced. That's the kind of balance that I think we need to have.
Well, you know, Senator Scott Motley, we can't do any more than to say to the public at large, as Senator Charles Sinclair has expressed, it's murder you're convicted for. And in fact, the original position in 92, if I recall, was either death or life imprisonment. But it was put as in non-capital that there should be a term so that it's not a mandatory life imprisonment, because the judiciary didn't like the idea of a sentence being mandatory. That's the position, okay? So that is why the alternative of 15 years was put. Now, when we come now and see what has been happening in the society because of the gravity and the numerous cases of murder, the executive says 15 years in the act as against life imprisonment is just too low. The judges should have a sentence at a higher level. Senator Binns and Senator Campbell, we want your views. Go ahead, Senator Charles.
Before you move off from Senator Scott Motley, because I just want to find out from my colleague, and we tend to agree on most things, you know.
Sorry?
We tend to agree on most things, although she sits across from me, but when we are in the other place, she's sitting on the same side and we're disagreeing today. Can you believe that? But I have heard all her comments and concerns that she has expressed. What we presently have is the 15. And am I to take it that Senator Scott Motley's position today is that it should remain at the 15? Is that what Senator Scott Motley is saying?
Well,
when we're discussing the issue of capital, she was in agreement that there should be an upward movement. The amount in the upward movement was not as proposed in the bill.
She proposed 40.
Correct. Which if you were to work it, yes, and you could work it out in the percentages, she keeps referring to, Senator Scott Motley, referring to 300%, but she seemed to have been prepared to go to 200 and something percent. On this particular issue, which still relates to murder, and when I listen to a lot of the presentations, I got the impression from the presenters that they were just looking at a situation where a person was killed. But my mind separates it, because you can have death by virtue. And you mentioned it, Chairman, when you spoke about the matters that bring a killing into the category of manslaughter, where you have a wider range. But in this case, it is murder. It is where somebody plans it, thinks about it, goes out and commits it. And I always think of the victim. You know, I read a particular article when someone was released, I won't say the name at this moment, having committed murder.
After 8 years?
No, well, it was a little longer for that person. And the comment by the person who was released was, he wants to spend the rest of his life with his friends. And it caused me to think of the person who was killed, to see that the victim, and their family, because they never spent another day of life with the person who was killed. Mm. But I'm just asking my colleague,
all right, before we come back to you, Senator
Scott, is it that
Scott,
she's saying, leave it at the 15?
No, we'll come back to her. Senator Campbell, Golden Campbell, you.
Chairman, it was a question I was asking. I got so enthralled with Senator Sinclair's comments that give me a moment, Mr. Chairman, I'll come back to you.
Senator Scott Motley, you want to respond to? You're back. Let's meet later this evening. I'll talk to you later. I'm in Parliament. I'll call you later. Good. Sorry, sir.
The question I was asking, in the capital situation where we're talking about life or death, yes? If a person is sentenced to death, that essentially in our system now is a life imprisonment.
Well, no. No.
No?
If the person is sentenced to death, then, which is rare.
Is it?
It's rare that I can't think of in recent times anyone being sentenced to death. Sometimes, so what usually happens is that the DPP may ask for the death penalty, but oftentimes, by the time the case is finished, it's a life imprisonment that is imposed.
There's actually, I mean, I've counted 6, 7, 8. I mean, it's not terribly frequent, but it happens. But in all of these cases, the Court of Appeal
yes.
Acted to lower the sentence. But I would be interested to know what happens in that case, because we've dealt with the minimum. We've put in a minimum mandatory for the life imprisonment.
For the capital murder, yes.
Right. But if someone is sentenced to death.
No, well, let's leave it at that. If someone is sentenced to death, and let us assume they go through the process, right up to the Privy Council, all the different things.
Right.
It can be imposed.
But let me ask my question. Let me ask my question,
But
please.
if it is not imposed, for
Chair,
example.
that's not my question.
Sorry.
I'm trying to understand. In the case, I think it was of Pratt and Morgan, where the time was too long, and the court said, at this point, you can't impose the death penalty. That is automatically commuted to a life imprisonment?
That's correct.
Okay, so it's not that we have a gap there
No.
that we have not provided for. That was my concern.
No. Yeah.
Right, so it would be life, and then the minimum mandatory would apply. Okay, I'm in agreement with Senator Sinclair on the non-capital murder.
So it's life or 40 years?
It was 35,
40,
right?
40, he said 40. He
No,
said 40.
No.
MP Williams said 30.
Huh?
No,
we're just doing life imprisonment one? Okay.
We have reached a minimum mandatory to be
I'm sorry.
served
Okay.
before parole, where either life or what alternative term Senator Sinclair recommend life or 40 years minimum for the judge to impose. MP Williams have said not 40 but 30, right? And so we're hearing you're going with whom?
MP Williams, I thought
I
thought Senator Sinclair was speaking about the minimum mandatory for the life
okay.
part. Sorry.
All right. Senator Gale, we're coming to Senator Gale and Senator Scott Motley and Senator Binns. Who is ready? Go ahead.
Senator Sinclair had raised a point, and I want him to take some time to look at the matrix at page 15, where the Office of Director of Public Prosecutions commented on the amendments which were proposed to Section 3. And the comment was that the changes proposed involve an increase of the minimum sentences which can be served for the offense of murder, with variations according to the types of murders recognized in the OAPA. There is nothing which prima facie appears to be in discord with the relevant laws and procedures. However, homage should be paid to the fact that the prosecution now enjoys the right of appeal, and in recent times have played an integral role in the sentencing process by way of submissions and the procurement of victim impact statements. The importance of this active role now being undertaken by prosecutors is to highlight the need for flexibility in the sentencing exercise as depending on the nature of the offense, the offender, and the public interest. The submissions may vary.
Having said that, what's your proposal?
So, Minister, I don't like the fact that you're rushing me to a proposal for life sentence for somebody's life, you know.
Look how patient.
All right. So let Senator Gale give his proposal.
In other words, what is being asked of you, what is being asked of you, Senator Binns, is the present law is life or a sentence not less than 15 years. The executive think 15 years is definitely not, because the judge could sentence to 18 years, 16 years. Where in fact, even a mandatory minimum sentence for being in possession of firearm is 15 years. So if you use that as your sort of reflection point, what then should be a person who is convicted of murder? What should be the minimum sentence that a judge can impose if he or she does not want to impose life? Bring your microphone.
Thank you. Mr. Chairman, I was hoping that Senator Gale would go ahead because I was just trying to remind myself of something I read in the DPP's presentation. And I really do need 5 minutes to just finish reading it.
Not a problem. Senator Gale, your any suggestion?
I was doing the same stuff.
In the meantime,
you know, I didn't come here without consultation, you know, but probably I'm an elected person. I'm elected in another capacity. I'm not, as my friend, member of parliament. But these are things that I speak with the persons, my constituents, to ask them, what is your view in relation to this particular bill? Posted it in a group, a WhatsApp group with over 300
I
members.
can tell you.
And you wouldn't want to hear some of the responses that came.
My constituents feel like you.
I noticed that the three persons sitting behind me who are here, and I suppose they can be the conscience of the committee at some point in time. But they don't face the electorate.
Mr. Chairman, and we really do not face the electorate, but as legislators, my dear senator colleague knows that it's important for us to strike the balance between what our electorate says and what is in the best interest of the governance of the country, and that's what we're trying to do. And who better to guide us than the office of the DPP? So we are simply just refreshing our memory to understand what she said so that when we make a contribution, it is based on something that is more than just something frivolous.
No, having said that, you want to give us your suggestion? Yeah. Bear in mind, you know, Senator Binns, you might be sitting at the bench and about to make sentence, and the court is waiting on you to say, what is your sentence? In the meantime, MP Williams, Senator Charles Sinclair and Campbell, we want to, the remaining portion, oh my God, we have the children want to deal with, you know. And we have this thing that we really wanted, and that's why the Ministry of Education is here. So we need to look, after we decide on this, we want the minimum sentence to be served, before parole, okay? So we need to put that in place too. So, yes?
Mr. Chairman, oh, Mr. Bailey is here. Through you to Mr. Bailey, from my understanding, with the minimum, what the minimum does is it says that the court can make a determination in excess, but certainly not below.
Quite.
Correct? All right. Because that was my understanding, and I'm looking back at something that the DPP office, the submission of the DPP on July 2023. And the concern I have, Mr. President, Mr. Chairman, is that I am not convinced that there is a need for us to change the minimum, because the authority still rests with the judiciary to impose a penalty, which can be in excess of the minimum. You've just confirmed my view. But at paragraph 14 of the DPP's presentation, she said, a vital aspect of the sentencing regime has been removed as the proposed amendments ignore the fact that the prescribed minimum penalty stipulated currently allows the court to impose either life imprisonment or a determinate term of a specified term of years that is fixed at a mandatory minimum. My understanding of what the DPP's office is saying is that the judiciary still has the discretion to impose a term not less than
the minimum.
15 years.
Yeah.
And if that is so, then why are we going to take away that power, that jurisdiction that the court has? And bearing in mind, Mr. Chairman, you said earlier when we started the discussion about non-capital, that the facts in every case vary so much. It depends on so many different considerations. And given that, then the court should still have the authority to consider all those matters and then make a determination. I am not convinced that the proposal, and it's not a rebuttal, Senator Sinclair, that the proposal by Senator Sinclair is going to satisfy us. I'm not convinced that the proposal...
But Senator Binns,
Yes.
Binns, where I think you see, if you don't mind me putting it this way, you could address the concerns you have about, say, the...
Instead of rebutting Senator Sinclair?
No, the offender. Okay. You could, for instance, at the moment, the law is that if the minimum sentence is 15 years, the person must serve 10, okay? The bill proposed 45, and you must serve 35. These are two which are being modified, for example, by the previous three persons who have indicated they wouldn't go to 45, they would go to 30 in two cases, and Senator Charles Sinclair says 40, but now they also have to consider, if we agree, whatever the figure is, what would be the minimum sentence to be served before you're concerned for parole, okay? Because at the moment, you see, Senator Binns, if the sentence is even 20 years, what would be the minimum to be served before you're considered for parole? These are matters which you should bear in mind in terms of the flexibility, and I'm not denying that the DPP now has a right of appeal and can go higher, as you understand. So,
yes,
I have to call you
Mr.
back.
Chairman, thank you.
I'll call you back shortly.
And I hear you, sir, but my position still maintains that I don't believe that sufficient argument has been provided why we need to disturb the minimum. Of course, at the end of the day, the decision rests with the government, but I am influenced by the submission of the DPP's office that, and my words now, there's no need at this point to change what it obtains. My understanding of her submission.
May I just, why I would persuade you, try to persuade you otherwise, Senator Binns, is remember now, the minimum sentence for a firearm offense is 15 years. To say that the minimum sentence for murder should be 15 years, you'll appreciate, look a bit inconsistent. That is why I would ask you to address, if you still agree that the minimum sentence which we now know is 15 years for firearm offense, what would be appropriate as the minimum sentence for murder? You still maintain it should still be 15 years?
Mr. Chairman, you will appreciate that I am constrained to give a figure at this point because I don't want to just get a figure out of my head. So
Okay,
it's something I
no
have
problem.
to think through, looking back at the submission.
No problem. Senator Gail?
Based on the fact, Chair, that the possession of a firearm sets and establishes a minimum of 15 years, I would not want to support equating the act of murder to be associated with that of possession. And so it has to be an increased over and above that. Again, we're talking now about that minimum period to serve, right?
No, no, no. The determinate sentence.
Yes. And so in that case, I am proposing 30.
Okay. Yes. Yeah, and they're now proposing 30. All right. All right, Senator Sinclair. Senator Sinclair, yours was 40. There are 3 other members who have said 30. You still maintain 40? Bearing in mind, we're talking about the minimum determinate sentence. It can be higher by the judge. But remember, we're talking not the period to be served, the sentence to be imposed. And we're the minimum sentence to be imposed, where the law now says 15 years. 3 members proposed 30, and you're saying 40, Senator Sinclair. And we're still to hear from Senator Scott Motley and Senator Binns. They didn't.
I just want to ask Senator Sinclair to look. I think the only group that actually made a proposal for sentencing was Jamaicans for Justice. And they had proposed moving to 25 years. So I want to just suggest to Senator Sinclair that he take it from there in terms of actually looking at you know, some group who had something in mind.
I have to call you back. I'm in Parliament. All right. No, wait. What do you say is the next? It has to be next week. It has to be next week. When? What PAC needs? And what I'm choosing? Then we will meet here? You sure? Senate meet this Friday? No, I can't even come. I will not even be this Friday. Let's see if we can knock out this one. Let's see if we get to meet with, she can meet in the chambers. She does have to meet in open parliament. And who are these? All of these, what is this? At what time? In the morning and evening? Well, those are ultimate. All right, colleagues, we need to wrap up this section. Senator Sinclair, you're 40, right? And they're 330. Senator Binns and Scott Motley, we need to just find out from you, though, your position. If for life imprisonment, if life imprisonment is imposed, what should be the minimum that must be served before being eligible for parole? Remember, so that's one other section. From the secretary, what is the nature of that thing?
That's for next week, Tuesday.
Mhm. What? It's a subcommittee of the JC. Hi, Juliet. Hello? The ladies come to a conclusion. 5 minutes more. Dealt with that as yet, you know. Hold. Okay, go ahead.
Mr. Chairman, I seem to have been nominated as the person to indicate or resolve. So in relation to the bill entitled An Act to Amend the Offences Against the Person Act, which proposes to amend. Did I lose my page? Sorry.
No, go ahead. We know what you're amending.
No, let me do this, Mr. Chairman. Let me do it the right way. Which proposes to amend Section 3 of the Offences Against the Person Act at Section 3(1)(b). We are saying that the word 15 should be deleted and replaced with the word 30.
And that's a consensus,
Yes, Mr. Chairman, I'm announcing the consensus between the members.
including sentence.
I'm not? I apologize. This seems to be the consensus of 5 members of the committee. Hold on, who is out of it? I'm not a very good negotiator if I can't determine that I have consensus or not.
No, Senator Sinclair had said 40, but the other 5 members saying 30.
Senator Scott Motley is part of the consensus, yes? Or no? It is a compromise. It is a compromise, absolutely. So at Section 3(1)(b), 15 would be replaced with 30. And at Section...
So if the person got life imprisonment, they must serve at least 30 years.
No, Chairman, that's not what the provision says. The provision says Section 2(2) shall be sentenced to imprisonment for life or such other term as the court considers appropriate, and we are saying not being less than 30 years.
Right, that's that section.
Yes.
Right.
So at Section 1C, that's where the minimum mandatories come in now, before you are eligible for parole. So at Section 1C, B1, we are saying...
Instead of 15.
Instead of 15, it should be 40.
Right, which is what is there, the
and
proposal.
at B1(2), we are saying that instead of 10, it should be 20.
Okay. And you agree with that? All right. You would come with that, Senator Sinclair, or you will... Sorry. Go ahead, SG.
The caucus skipped one big CA.
Sorry?
One big CA.
They did it. This was
50?
for the
And
capital
it's agreed
murder.
to 50.
That was the capital
Oh,
murder.
it's agreed for 50. Okay.
Right. So the proposal, the majority had agreed and maintained in the 50. C remains, and D, instead of 35, the proposal is 20. Agreed? All right. So in relation, just to, sorry, go ahead, Mr. Bailey.
Minister, I'm just wondering, it was just said that C will remain, but C is the...
No, C is where the person is sentenced to life. No, let's just look at the bill. Look at the bill, the proposal and the bill. No, please, just for the record, in relation to 1B, we're deleting 15 and substituting, therefore, not 45. What was the figure we had? 30. In other words, in the determinate sentence, we're moving from 45 to 30. The minimum to be served. 30. Agreed? In B, it remains. By deleting 20, we're substituting, therefore, the word 50. In 1CB1, by deleting the words 15 and therefore the word, what was the figure? 30? 40. We're keeping 40. So B and C in the bill remain, and D instead of the word 10, instead of 35, we're putting 25. 20. So basically, it's only A and B where the proposals vary. Agreed? No, members, do we agree? Colleagues, do we agree? The two changes are to A and D, as indicated, and B and C remain in the bill. But in relation to A, we're moving from 15 to 30, right? And in D, we're moving from 35 to 20. Okay, minimum to be served. Colleagues, I want to thank you. We have to depart from the Parliament by 1 o'clock, and we had the Ministry of Education here. I thought we would have been able to deal with the Ministry of the sentence for children, and there's also one other item which is a slight adjustment in light of these changes. We have to do a slight adjustment to the Criminal Justice Amendment Act. Colleagues, I'm going to recommend that we return next week, Tuesday. There may be a meeting later in the morning. I'm begging you. Not possible next Tuesday?
I am traveling, so if the committee would permit me to attend online. I don't know if we have made provision for that.
When do you return, if you don't mind me asking?
The end of the week.
What did you have? Where are we? What is this? What's here?
It's not a complicated motion. It could be moved in the House this afternoon to allow it.
Or alternatively, we have discussion on your position, and then I just present it.
I prefer the first alternative.
Can you get us move the motion? So colleagues, it may well be, just to make sure we can conclude our position, we do a resolution this afternoon, and we find an appropriate time that we can do this virtually to conclude. Okay? So we will right. Because to be frank with you, it may well be that we start out next week Tuesday quite early, so we can just conclude this matter. Because we need to conclude so we can report. I want to thank the members, though, for really assisting us in having a consensus to recommend to the Parliament. I want to thank the technical team. You see what was being discussed. And if there are any concerns, please let us know. But we need to conclude. I thought we would have concluded today. But, and CPC had provided us with some proposed changes for the children's Ministry of Education. Please have a look at that. Please come with some good suggestions as to the gap to be filled in, right? So we see what can happen when we return. We're hoping, please, colleagues, have a look at the children's sentence and also at the amendment to Section 42 of the Criminal Justice Amendment Act, so we can conclude definitely next week. I've asked the Secretary to start drafting a report, which we're hoping can be presented by the middle of November. So we want to conclude next week, Tuesday. Hopefully we pass the resolution. It may be next week, Tuesday, about 9 o'clock. We can do a lot of it virtually, okay? Thanks again, everyone. Can I have a motion for adjournment? Joint Select Committee is adjourned.